Assalamualaikum warahmatullahi wabarakatuh. I will be reporting the first part of Chapter 10, Duties and Liabilities of Directors, Trustees, and Officers when they enter their offices, as well as the personal liabilities they may incur in the exercise of their fiduciary responsibilities in pursuing the business of the corporation. The primary objectives of the Board of Directors. First is the maximization of profits, where the Board of Directors of a stock corporation is to seek the maximum amount of profits for the corporation and characterize the director's position as a position of trust. And in case a director's interests conflict with those of the corporations, such director cannot sacrifice the latter for that of his own advantage and benefits. Second is enhancing the value of the corporation, where what is novel is that corporate governance reforms seek to effect a paradigm shift into these fundamental corporate attributes by expanding the fiduciary duties and obligations of the board of directors and management of corporations, whereas they are vested with public interest from exclusively the shareholders to include all those affected by business enterprise of the operation, of which are the stakeholders. Liabilities of directors, trustees, and officers. In Shamat Mercantile Incorporated versus Court of Appeals, the Supreme Court came up with a formula for determining the issue of personal liability for corporate officers. Thus, first, he assents to a patently unlawful act of the corporation for bad faith or gross negligence in directing its affairs, for conflict of interest resulting in damages to the corporation, its stockholders, or other persons. Second, he consents to the issuance of watered stocks or who, having knowledge thereof, does not forthwith file with the corporate secretary his written obligation thereto. Third, he agrees to hold himself personally and solidarily liable. And lastly, he is made by a specific provision of law to personally answer for this corporate action. By the use of the phrase may so validly attach as a rule only when it is clear that the general rule is that directors, trustees, and officers are not personally liable for the corporate debts and liabilities, and that the only time they do become personally liable is on the specifically enumerated four areas indicated in the formula. In the absence of malice, bad faith, or a specific provision of law making a corporate office liable, such corporate officer cannot be made personally liable for corporate liabilities. Second is the divergence reigns on a rule on non-personal liability in labor law cases. Since the 2003 decision in NYK International Network Corporation versus NLRC, the Supreme Court has applied only to the Sonia Doctrine, which expressly provided that there is nothing in the language of Article 212C of the Labor Code that expressly makes any corporate officer personally liable for the debts of a corporation, and that the governing law on personal liability of directors for debts of the corporation is still now what is now Section 30 of the Revised Corporation Code. Rules on fiduciaries, duties, and liabilities. Directors as fiduciaries under the doctrine of creature of limited powers, the board of directors and management are bounded by the fiduciary duty of obedience. On the other hand, by virtue of the attribute of centralized management embodied under Section 22 of the RCC, constitutes that board of directors as the naked or legal title holder of the property, assets, and business enterprise of the corporation for the benefit of the shareholders or members, the fiduciary relationship of the directors, trustees, and officers to the shareholders or members giving rise to the duties of diligence and loyalty. In the Philippine jurisdiction, the members of the board of directors have threefold duties as well. First, duty of obedience, duty of loyalty, and duty of diligence. Duty of obedience under Section 24 provides that the directors needs to direct the affairs of the corporation only in accordance with the purposes for which it was organized. Duty of loyalty under sections 30 and 33 provides that directors or trustees shall not acquire any personal or pecuniary interest in conflict with their duty as such directors or trustees. Under the duty of diligence provides that directors and or trustees shall not willfully and knowingly vote for or assent to patently unlawful acts of the corporation or act in bad faith or with gross negligence in directing the affairs of the corporation. What is doctrine of corporate opportunity? If there is presented to a corporate officer or director a business opportunity which the corporation has an interest or a reasonable expectancy, the self-interest of the officer or permit him to seize the opportunity even if he will use his own fund in the venture if he seizes the opportunity thereby obtaining profits to the expense of the corporation, he must account all the profits by refunding the same to the corporations. Now there are exceptions. The act of the director has been ratified by a vote of the stockholders owning or representing at least two-thirds of the outstanding capital stock. We must always remember that violations of sections 30 and 33 are not penal offenses in relation to section 158 of the RCC. Now, how about the duties on related party transactions or RPT? Under Section 31, by self-dealing directors with a corporation, a contract of the corporation with its directors or trustees or officers or their spouses and relatives within the fourth civil degree of consanguinity or affinity is voidable at the option of such corporation, unless the following are present. First, the presence of such director, trustee in the board meeting in which the contract was approved was not necessary to constitute a quorum. Second, the vote of such director or trustee was not necessary for the contract's approval. Third, the contract is fair and reasonable. Fourth, in case of corporations vested with public interest, material contracts are approved by at least two-thirds of the entire membership of the board, with at least a majority of the independent directors voting to approve the material contract. And lastly, in case of an officer, the contract with him has been previously authorized by the board. Now, when any of the three conditions set forth in and there is one absent, such contract may be ratified by the vote of the stockholders representing at least two-thirds of the outstanding capital stocks or at least two-thirds of the members in a meeting called for the purpose, and full disclosure of the adverse interest of the directors or trustees involved in such meeting and their contract is fair and reasonable under such circumstances. And lastly, the material related party transaction for publicly listed companies. Now, the rules of material related party transactions recognize that transactions between and among related parties may create financial, commercial, and economic benefits to individual institutions and to the entire group where said institutions belong. In this regard, related party transactions are generally allowed provided that when RPTs amount to 10% or higher of a company's total assets, it shall be considered as material related party transactions subject to these rules. The compliance to these rules shall be mandatory for all PLCs. Now let's hear Barry Dumama for the second part of our report.
Assalamualaikum. In continuation with Ms. Tiso's report regarding duties and obligations of directors, trustees, and officers. The next is the contracts between corporations with interlocking directors. An interlocking director is a director of a corporation wherein he transacts business with another corporation, and he also sits in that corporation as a director. How does existence of interlocking directors affect contracts between corporations? Generally, these contracts are not invalidated. They are not per se deemed fraudulent or voidable, provided that there is no fraud and the contract is fair and reasonable under the circumstances. The next duty is to maintain and allow inspection and or reproduction of corporate records. And one of the significant corporate governance reforms introduced under revised corporation code is the formal institution of the fiduciary duty to maintain records and to report on significant corporate information. The principle behind this reform is the enforcement of the corporate governance principles of transparency and accountability. Pursuant to the corporate governance doctrines of transparency and accountability, the revised corporation code provides for the duty to report on key corporate governance data. The applicable provisions under Section 25, the submission to SEC of names, nationalities, addresses, and shareholdings of directors, trustees, and officers. Also under Section 28, notifying the SEC within 3 days from the creation of an emergency board stating the reasons for its creation. Last is under Section 49 of the same code provides that at each regular meeting of shareholders or members, the BOD shall present the minutes of the meetings, material information, corporation's performance, financial reports, dividends policies, director or trustee profiles and attendance report, appraisal and performance reports, compensation reports, disclosure on self-dealings, and profiles of directors or trustees seeking election or re-election. Another duty is the duty to maintain records and obligations to report on beneficial ownership. A beneficial owner is a natural person who, first, ultimately owns or controls the corporation, or second, exercises ultimate effective control over the corporation. These are the guidelines on determination of beneficial owner. First is the identity of natural person who ultimately has controlling ownership interest. Second is the identity of natural persons, if any, exercising control of corporation through other means. Third is the identity of the natural persons composing the board of directors or any similar body and or the senior managing official of the reporting corporation. What are these watered stocks? They are shares issued for a consideration less than its par or issued value, and in any form other than cash, valued in excess of its fair value. What is the liability of a director or officer consenting to issuance of watered stocks or having knowledge thereof without objection? They shall be solidarily liable with the shareholder concerned to the corporation or its creditors for the difference between the fair value and the par or issued value of the same. And the last is the obligation to remove disqualified director or trustees that under last paragraph of Section 27 of the Revised Corporation Code provides that the removal of the disqualified director shall be without prejudice to other sanctions that the SEC may impose on the board of directors who, with knowledge of disqualification, failed to remove such director or trustee. What does the corporate fraud or tort mean? It acknowledges the directors or trustees who willfully or knowingly vote for an assent to patently unlawful acts of the corporation or who are guilty of gross negligence or bad faith in directing the affairs of the corporation or acquire any personal or pecuniary interest in conflict with their duties, shall be liable jointly and severally for all damages resulting therefrom suffered by the corporation, its stockholders or members, and other persons such as corporate creditors. What does the trust fund doctrine provide? The shareholders to whom assets of an insolvent corporation have been transferred are liable to creditors upon dissolution of the corporation. Broadly, the doctrine provides that corporate assets are held as a trust fund for the benefit of shareholders and creditors, and that corporate officers have a fiduciary duty to deal with them properly. So in other words, it would be a violation of the rights of the creditors of the corporation to allow the return to the shareholders of their capital or to declare dividends outside of the unrestricted retained earnings. Likewise, upon insolvency of the corporation, the board of directors of a corporation is duty-bound to hold the assets of the corporation primarily first for the payment of the corporation's liabilities. And in the case of Steinberg versus Velasco, the court held that directors did not act with diligence when it took the word of their chairman at face value without making an informed decision based on the facts then available to them and on not relying on other documents available to them, which worked to the detriment of the creditors. That is all, and wassalam.